Shh, shh. The podcast is starting. Welcome to the OT Download, from practice to podcast. This is where we unpack everything you didn't know you needed to know about occupational therapy. Whether you're an OT, an OTA, a student, or simply curious, this is your place to explore the real stories, challenges, and opportunities shaping our profession. Each episode will dive into fresh topics from ethics to AI in practice, to the dynamics between OTs and AHAs, the differences between community and medico-legal work, and even what it's like stepping into the courtroom. You'll hear honest conversations on mental health, well-being, boundaries, and early career experiences, alongside insights from lawyers, allied health professionals, and other experts. We'll bust common misconceptions and shine a light on the parts of OT that don't always get spoken about. So if you're ready for insights, stories, and a no-nonsense take on occupational therapy, this is your download. Let's get into it.
Welcome back to the OT Download. In episode 3, you would have met my colleague Callie and I when we spoke about the basics and foundations of medico-legal OT. Today we're going to build on that further and dive deeper into how we can draft a report which is based on objective findings and medical evidence which we can use to be clearly defensible in court. And to do that, I'm joined today by Katie, our General Manager at MLEA and Medico-Legal OT. Hello, Katie.
Hello.
And I also have Vanessa, our Director and Founder, who's also here to talk with us. Thanks for joining, V.
Pleasure. I'm honoured to be here.
So we're going to dive into how OT is used in a legal proceeding, what constitutes objectivity under scrutiny, and how to navigate the medico-legal landscape. So we're going to jump right in, V. Mm-hmm. First question's for you.
Fire away.
So Mia's already touched on this, but she and Callie covered off on what is medical legal OT and how it differs from clinical areas of practice in the last episode. So I guess using that information, can you talk us through how OT is valued within the legal realm, mm-hmm. and, you know, what lawyers find valuable about our reports?
Yeah, absolutely. So we're valued because of our profession. Mm-hmm. As OTs, we pretty much are the most equipped to comment on all the areas of the legal parameters of the claim, mm-hmm. Which focus on loss. And when you look at loss, you're looking at function, and that's our world. So
the bread and butter of OT,
that's
right?
our world. So, you know, I'm really proud that OT is the profession that holds so much weight. And over the years, and, you know, just in my experience, I've been doing this for a long time, not so much recently, but over the years, the value that I see lawyers, barristers and judges put on our reports has grown to the point, you know, our business has grown because of that. We've become much more focused on objectivity because we understand their world more. And at MLEA, we have taken special care to understand the legal side much more. Reports as well, alongside medical specialists, very important in the actual diagnosis. So with their help in really focusing on the compensable injuries, we can then hone our opinion to be very precise in terms of the damages that arise from the condition or the injury that was sustained in what we always say, the subject. So, you know, not only do they need OTs to kind of do this assessment to look at the impact of the injury, but they need us to look at what then that client needs or can't do as a result. And that's function going from, you know, the impairment of the injury and how and the impairment could be like a physical symptom impairment, how that impairment translates to loss of function. And then as OTs, I think it's really important that we recognise our role in getting someone back to their lifestyle without bias, because we really want someone to be able to maximise their function, and that is what we do. So we are not always recommending care. We are looking at ways that they can be independent first And then if they really can't do something, then we look at how someone else needs to come in and do it for them. But we would be doing them a disservice if we just recommended care.
And I guess part of that, like, you're reputable, you know, within the industry, is that you don't over recommend, right? Is that, you know, lawyers appreciate probably a more conservative approach sometimes because you're not over inflating their needs and therefore it's easier to defend when they're in mediation.
Absolutely. And I think, you know, we have an obligation and a responsibility to be as objective as possible, and mainly for that client, so that they do not lose their sense of worth. They, you know, if they can do something with equipment or if they can do something with therapy, that's what we would recommend. The damages, yes, can be the cost of the equipment, it can be the cost of the therapy, but the big parts of a claim are usually care. And and
like care recommendations.
And there are definitely circumstances where someone really cannot do something either, individually, like a once-off, or continuously across the week or whatever it might be, because they need to sustain whatever we're saying they can do. So if they can do it once, well, that's not going to help them. So,
but it's not telling a true picture of their actual function if they can do it once, right?
So you might say, well, they can do part of that, but then they need someone to do the heavier components or the more repetitive components.
So you're like, can they do it independently? Yes or no? Can they do it at what cost? If the answer is no, then that's when you recommend the care, right? Because for me, care should come last because it is the most expensive thing. And as an objective OT writing an opinion, that most expensive component, like, it should be reasonable, right? And if they can do it in some other form with equipment or anything like that, then that's the first thing that you should look at.
Yeah, absolutely.
Have you ever had a lawyer, I think we all have, not quite happy with your opinion because you've gone too conservative or
the other way,
or the other way around
in their perspective?
Because I find that can influence your bias, right?
Yeah. Well, absolutely. And, you know, when you say the word conservative, I think that's an important term because we really shouldn't be conservative. We really should be objective. You know, like, if you are really true to your profession, you use clinical judgment, and the tests that we do, we choose them so that we can rely on objectivity. You can't test everything, as you know, so that FCE has to be a combination of those tests, which are, you know, finite measurements and scoring and stuff like that. Then we compare that to observation, right? So do the results of those tests align with what we're seeing? And often there's an imbalance because the tests might say they can do something, but they're self-limiting or whatever. There's a lot of reasons. And there might be a psychological component because they're fearful of pain or symptom exacerbation if they move. Yeah, absolutely. So you know, there's this process. So there's, you know, what they report, what we observe, and what the tests say. And I always say that's like a triangulated opinion because you have to take into account all of them. And then you have to take into account the fact that, you know, that person lives in circumstances that are not a clinical environment. So you have to take that into account.
Not a controlled
it's complex.
Yeah.
But, you know, we do it. So kind of, what would you say, intuitively, because we know what our job is, we know our staff, and somehow we pull it all together, and that's what I think. I do think that lawyers and judges and barristers do value that. I think that they do now. They probably didn't.
It's taken a while.
It's taken a while
in the industry,
and it's not just, you know, us. I mean, even though, you know, I have created amazing medico-legal OTs.
What other sort of factors, or is there anything else that we haven't yet spoken about that you feel as though really helps to building an impartial and objective rapport?
Yes, definitely that file review. And just to explain that a little bit more for OTs that might not understand why we're doing it, because we look at timelines. So the timeline really is that, well, the centre of it is the incident, the date of that incident, and what we're really doing, and medical professionals like specialists, etc. We're looking at the loss between who that person was literally the day before the accident and the change the day after or the day of and after the accident. And then you've got recovery, recuperation, adaptation, therapy, and all of those things that come from the date of the accident right up until the day we see them. So, you know, getting that evidence and pulling that out so we understand the trajectory of that injury and how it's impacted their life. So,
and sometimes that can be 12 months, sometimes it can be 8 years.
It could
since
be
their injury.
Absolutely.
Yep.
And you know, don't really go into all the complexities of going back to 8 years. But what I know we do is, because we've done that evidence review, you have a timeline, because you're like, well, injury, then they were in hospital,
some surgery,
then discharge. So you look at the discharge summary. What were they told that they have to do?
Were they
on crutches or whatever? Which tells you, well, they're on crutches, so it's going to be tricky doing gardening and stuff like that. So, you know, all this information, even like for me, from when I was doing the assessments, and I know you girls do it too, the discharge summaries were really important. Not so much all the hospital records in between, GP records, any sort of like physio assessment,
rehabilitative services.
Yeah, and you just kind of pull it out and you go. And then when we're in the assessment, because we're asking them to recall 8 years back, you're like, and they might say, I think I was okay then. I think I was off the crutches, and you're like, no, you weren't actually. You were noted to be
on this, and you were still on crutches.
You arrived at the physio on crutches, or you were wearing a moon boot. So and then they go, oh yeah, that's right. So we trigger it the whole way along.
Yeah, it's almost like Hansel and Gretel, like breadcrumbs through the evidence.
Absolutely, and that then makes their hearsay, which you know is a weaker
form of evidence,
but it makes their hearsay much more reliable. And of course, you know, we factor in bias from, you know, like in my experience, I've sat with guys who are really stoic and going, oh yeah, I was doing all of that.
Like, I was
and
fine.
then the wife's there going, no,
shaking
you weren't.
her head in the background.
No, you weren't.
Oh, the amount. If I had $1 for every time that happened.
Exactly.
So then we learnt from that, because then we said to lawyers, we want the caregiver to come to the assessment to further improve the objectivity of our assessment. So everything we do and all the changes we've made through talking to the lawyers, through going to court, which I know we'll talk about, have all been meshed into our process. So any OT that comes on board to MLEA doesn't have to know all of that or learn all of that, because we've learnt it all. And it's all in our beautiful processes. We're very process driven, I know. But I think that just allows people to really focus on their profession rather than all the noise that's around it.
Absolutely.
So as the name of this episode suggests, we're going to talk about courtroom experience and what it's like to give an expert testimony, V. So this is probably taking you back a few years to when you were going to court. And I know prior to COVID, you'd be in person, right?
Yep.
So what do you think OTs would want to know about the reality of giving evidence as an expert witness?
Against the background of a really good report, right? So we've already established that, you know, there's lots of ways to make our report watertight. And I suppose all of that's really important to your confidence. So, you know, knowing that, you know, you've done a good report, you know, your opinions sound, all of that, then yes, it always is a little bit kind of daunting, scary, maybe. And when you think of why, it's because someone's going to question your opinion. I always used to tell myself, look, I'm an OT. I'm there for a reason. I'm there to offer, help to the lawyers, the barristers, and ultimately the judges, and to the client, help for them to make a fair determination or judgment on this case.
Yeah.
So, so you have to kind of, just really have that confidence. And then, really there's a whole preparation process that gradually diminishes your nerves. And that preparation process, I think, I don't know if it's still the case, but we generally do not start prep until the day or 2 days before, because often these cases settle, which, sometimes, I have to be honest, sometimes I'm disappointed when they settle. I have
Why?
been.
Because you're like ready to go.
I'm ready to
fired
go.
up. No, I'm joking.
And then you think about it when, like, you haven't had the experience, but when you are asked to really justify your opinion and you know that you've done a good job, well, it's just really exhilarating.
Yeah.
It's
Come
like,
at me, I'm ready.
Yeah, it is. Like, it's really weird. But it's like you have all the adrenaline and then, and I mean, and look, the other thing too, sometimes you might go back and read through a report and go, oh my God, I didn't explain that properly.
Yeah.
And then, thankfully, we scan all our notes and we have all those records. So then, because you're looking at the report, so you go back to your notes and you're like, oh yeah, I just didn't put that in the report, but I have the notes.
Yeah.
Sometimes you provide that to the lawyers so that they can see if it's a bit of a gap. But generally, you kind of work your way through that, and you have to just kind of drop the ego, I think, and just be professional.
Yeah.
And then, a lot of the time it goes to court because there are two opposing opinions, right? Which, when you think about it, we're human, we're OTs, professionals, we can't all think exactly the same.
Yeah.
So that's bound to happen. But again, coming back to our reports and our process, we have such a tight, sound process that, you can rely on your opinion, but also you accept and kind of understand, I suppose, the other OT's opinion. And sometimes, I have said, look, you're right. You've seen this person a year later.
Yeah.
I absolutely agree with you. If these things have changed, I agree.
Then, yeah.
Because, in my experience, I've got a few trials
Well, you've
coming
done
up.
reassessments.
But there are clients that I saw in 2022 or 2023.
Yeah.
So your importance of looking through your notes, not just your report, but having good documentation.
Yeah.
No matter as long as you can understand it.
Yeah.
And you can make sense of it. I just think that's gold.
Because
right?
what all that stuff doesn't always end up in the report.
Exactly.
Because you're just
Well, as
pulling
your
out
report
what
would
you
be
need to.
Huge.
chapters long.
Yeah,
even
so
longer
it's
than
kind of
what
like
it
a
is.
funnel, really. Like you start off with lots of information, then you pick the stuff
Whittle
that's
it down.
relevant,
Yeah.
and then but what's up there can sometimes fill that gap. That
And
you
I know
need
we
it
always
to.
talk about barristers or lawyers saying always state the obvious. Do you want to talk a bit
Absolutely.
about that?
Time you get to court, there's you've already seen all the evidence, and if there's any new evidence that they're presenting, then you see it before you go to court, right? So it's very organised in that way. So so if there is anything, maybe, well, it would be like it's something that say a lawyer or another layperson would naturally think would be the progression of a certain matter. I'm trying to think of an example, but there are certain when you're looking at something like you generally will go, oh yeah, well that's likely
That's
to
obvious.
have happened. That's obvious, but it's actually we don't think it's even relevant, but. Because we know that someone else might go down that path or come to some conclusion, we always bring it into the report
Yep.
to then rationalise it so that they understand. So it's really important we do that.
And I think that also probably links in I know feedback you've given to Katie and I, advice has been like, always very clearly state your assumptions.
Yes.
Like what
We love
assumptions
an
is
assumption,
that?
don't we?
Yeah.
Yes.
What assumptions is that opinion based on?
Yep.
So there's in that way no confusion for the reader around that. Hey.
Absolutely.
Yeah.
So everything in the report has to have a source.
Yep.
Right? So that's why we say he reported, she reported, according to whatever doctor or record or whatever, and it's footnoted. Everything can be sourced either to hearsay or a document.
Yeah.
Yeah. And then, assumptions, well, you use them mainly when, the circumstances of a situation don't quite fit the question.
Yeah.
Yep.
And then you have to, you know all the information and you have your clinical reasoning, but there might be an assumption of like if he was to move away from living with his
That's
parents.
a common one that I use.
Yeah.
If I'm assessing someone who's about 18 at the time of their injury and they still live with their parents, then we make an assumption that in the future, if they were to move out to a similar size property or something like that, you would base your care recommendations on what you would assume the property that they would move into.
Yeah, and I suppose what you're saying is mainly future needs.
Yeah.
Pretty much, because you can't predict the future. But yeah, you don't know what sort of house he's going to move into. He might buy a mansion. You never know. He could win the lotto and buy a mansion. But we have to say, well, we would recommend a 2-bedroom apartment
low
on low set ground, with minimal
with lift
lawns.
access or whatever it might be. And on those assumptions, this is the services he would need. And if you then get to the court, into the trial, and there is a new reality, like he has got his mansion, then we would want to see the mansion and then provide another opinion.
Which is what we do in like a supplementary report.
And you've got to keep in mind we only see a person for 2 to 3 hours. So there's lots of assumptions you might need to make
outside of the circumstances we see them in.
Yeah, but that is really protected by the assumption that their condition is stable and stationary. And that means that we can go, what we see today is what
their function's going to be for years to come.
And that is an assumption when you think about it.
And at the end of the day, I mean, we're writing our opinions on that premise, is that their function's stable and stationary, and this is going to be the case up until retirement age or beyond. I was just writing a report this week about someone who'd had 2 previous back injuries but was still able to maintain work as a plumber, which is pretty heavy work.
Absolutely.
And then he's had this 3rd back injury, so same compensable injury as his previous. But he now cannot work.
But different.
So he's had a couple of surgeries now as a result of the 3rd one. But it's, as we say, it's so important to acknowledge here's the previous back injuries. And at that time he was still working full time, or, you kind of, and tax records can tell the story of if someone is working.
Totally.
So that's the evidence that comes out.
And HR
the T.
records
Exactly.
and time lost and sick days and the GP records. There's so
you
many
can't really
sources.
feign that
No,
information, right?
no.
Because the lawyers have access to all the tax records and all
Absolutely.
their
So preparing for the report for the trial. Do you want me to just kind of tell you what my process was?
Yeah, what's the process, I guess? So, the first thing that we hear is that you get an email from the instructing solicitor to say, trial date's been set, can you clear your calendar? And it could be for, I've got one in August, which I found out about last year. So you get a lot of time.
Yes.
Obviously, I'm not going to look at that until such a time. So can you talk us through, from getting that email, what would happen if that proceeds to trial?
Okay, and a little bit about our process. So you get the letter, right, and then it gets booked in, and ordinarily, like you said, we probably don't do much because we've got other people we're seeing and what have you. We don't really want to incur costs for the lawyers unless we need to. So our rule is that we just don't do anything until the week before you might start pulling out the report and having a brief look at it.
Yeah.
And looking back at your report, and I would say reading it word for word. And somehow it's kind of different. When we're writing the report and we do a cross edit and we do a proofread, you've got a different lens.
You're trying to find holes in your own report.
Critical lens.
Yeah.
What are they going to question me on?
Yeah.
Is the first thing I do is go to my FCE and go, okay, well, what did I find? What were his impairments? What are the objective things? And all of that. Was that all fair? And then I look at that and go, okay, well, that's fine. And then usually you've got another OT opinion. So, there's those factors too, what they found and what have you. But you go through your report and really try and get your head across your opinion.
Yeah.
You haven't seen it for like 2 years or something. And so you do that. And then maybe 2 days before you might start really starting to poke holes in it. Like you're actually becoming very critical of your own opinion because you want to make sure that you really understand how you arrived at an opinion.
Yeah.
And you want to be self-critical. So sometimes you sort of inherently know, because you've got the other OT report, you might have other reports that you're looking at, you kind of know what the contentious issues are. So you start drilling down into those, and your report says a certain amount of stuff, but then I would go, oh God, that all comes back to that, so let's say manual muscle testing, or the fact that he couldn't squat, or his lifting or whatever. So then I look at the test protocols and make sure I understand exactly their reliability and objectivity, because you might have to defend the test itself.
This is giving me flashbacks to a gentleman I saw in Cairns a while ago, and I had to respond to the defendant OT who had provided a report.
Yeah.
And I saw this gentleman in a home visit in Cairns, maybe 2 years ago or something. And in the other OT's report that he'd seen, I think his strength capacity with me was maybe sedentary or light or something like that. And the other OT had put forward that they rated him as medium because he could lift, 22 kilos from all these different heights. But then when you actually looked at the other OT's report in a lot more detail, there was no sort of specification around how many reps, like in what environment. So all of those things weren't really specified at all. So I think, like you said, having a really good understanding of the protocols around your FCE testing is so important.
Yeah, and like the research that went into developing those test batteries, right? Because and on occasion I've even got to the point of, I think it was with hand grip strength, looking at the norms for different populations.
We still do that.
Yeah.
Norms for females versus males, kids
Between in different age ranges as well, because it changes.
Yeah, which, we luckily have an FCE that's been designed with all of that in mind. So
It's already
like
embedded.
our lifting protocol is Leonard Matheson. So there's all these, what do you say, barriers, I suppose, built in so that we're only using tests that are valid and reliable. So anyway, you look at that first, and then
Pre-trial conference, do you ever meet with the barrister?
But you do all of that before the
Before
pre-trial
you meet up with
conference, because that is your first cross-examination in a way, because it's kind of evidence in chief. Evidence in chief. Because they're the ones that need you to answer these particular weaknesses in the case, or big issues in the case, or whatever. So they give you like a window into the court, like the court situation in many respects, because they say, well, no, we're not even worried about that.
Right.
We're worried about the work capacity side. That you said he could go back to being, an accountant.
Yeah.
And someone else has said that he can't do it, or whatever it might be. So that gives you a bit of insight. So then after that, you're like, right, now I need to
tailor it,
really
even,
get in.
Yeah.
And I just go through it and write notes. And then if it's like on the phone, different if you're in the courtroom, which thankfully that doesn't happen anymore. I used to have all my notes on the bench, kitchen bench.
Yeah.
And you're on the phone and you just pull out what you need.
Yeah, okay.
And you're like, okay, and you talk.
Yeah.
Yep.
Yeah. So
And
it's literally
easy.
like on the phone. You just chatting.
It's literally
through
on
or-
speakerphone.
Yeah.
And you can
wow.
only really be questioned about what's in your report.
Absolutely.
So as long as you are going through that with a fine-tooth comb and you know your own report back to front and you've done a solid FCE grounded in evidence and objective testing, there shouldn't be anything to worry about.
Yeah, and that just reminded me there was lots of situations where I would say, well, there's a couple of things. Remind me. I'll probably forget them. I would really listen to the question and then I would pause.
Give
And
yourself time
then,
to think.
like, I think everyone does it. You pause and formulate what you're going to say first, and then you say it. And everyone kind of expects that pause. Or if they've asked a really convoluted question, you might say, I don't understand what you're asking me. Would you rephrase that?
So it gives you some time.
It's actually interesting because I did that exactly in the mock trial course that we volunteer in to be expert or to be witnesses. I had one of the defendant barrister in training asked me, and obviously he was in training too, which is fair enough, but he asked me this question that was so complex that me as the fake, character witness, I actually had to say, I'm sorry, I don't really understand what you're asking. Can you repeat that again? And so then he sort of like went back to his notes and was like, okay, yes. And he asked it again. It made a lot more sense. But that's such a good point. Give yourself time to think as well.
And they'll often say, on page 23 of your report, you say this. And you're like, okay, you have to flick to page 23. Then you have to read page 23, right? And then you have to formulate your opinion. And in some cases, they're saying, well, Dr. X said this and you're saying that. Why would that be? And sometimes, there is no answer. Sometimes it's like, look, I really don't understand why his opinion would be different to mine. It could be that he saw our client on another day or that was a good day for him and I saw him on a bad day or vice versa. And that's why in our FCEs we put good days and bad days because everyone has good days and bad days.
This might be controversial, but I guess, Dr. X has a certain opinion about work capacity.
Yeah.
Is Dr. X an OT who is
grounded
in function or are they an orthopedic surgeon who actually should have a medical opinion?
Absolutely. And you can say, that's when you can pull your experience in and say, well, I'm not sure about Dr. X's experience in doing workplace assessments, but I've done probably in my career 1,000. I've gone into the workplace. I've done return to work programs and task analysis and all of that. And I break it down module by module in terms of the task demands versus the capacity, and I just really rave on about that sort of stuff. Because there are occupational physicians who do have more experience. And so, their opinion is a bit more weighty, I suppose, to more clinical medico-legal specialist. Medical specialist.
It is interesting though, because you often obviously see in a brief of evidence, like there's doctors' reports that provide diagnosis, prognosis, and they provide the percentage of whole person impairment, right?
Yeah.
So, and then the solicitor in the letter of instruction to the doctor, orthopedic surgeon, let's say, will say, what's your opinion on their work capacity? And they'll be like, oh yeah, they could do some kind of full-time work. And it's almost like two sentences.
It's two sentences, but
and
it's
then
good that it is.
Yeah.
Good that it is.
But sometimes their opinions are completely different to what we think. And we're both writing reports for the plaintiff, or, we're both kind of working on the same side. but they've just made this almost throwaway. Yeah, they could go back to some form of work, but it'll struggle.
Yeah, and look, that could come back to the LOI that we're given.
Of course.
They probably, we get the medical doctors, what's the diagnosis? We're like, well, no, we're not going to comment on that.
Yeah,
that's
we
their
do.
job. And they get, well, what's the work capacity? Or ADLs. Like, oh, okay. But I think everyone understands that OTs are the gurus
Of work capacity.
ADL. I think we trump everyone.
Yeah.
I think we do.
Yeah.
And so we should.
Yeah.
But I mean, they're not doing tests like, we talk about our dynamic lifting test where we're doing certain screening within our FCE. We determine what they can lift for how long safely.
In what
what's
environment?
in what environment, what are their symptoms doing during this lifting test, and then we categorize them. They don't do any of that kind of thing. So I think when you talk about us being the gurus, which we are, like really there's a lot more evidence grounding our opinions than the doctors.
Yeah, they try to discredit you because that's their job. It's like, it's not personal. It's not personal. It's not personal.
It can be so hard to not
Separate
take
that.
Yeah, to not
It's
take
not
it personally.
personal,
Because Katie and I have had solicitors previously make the comment that, if I saw this one OT get obliterated on the stand,
I was going to bring this up.
if that happens, like, that's career over for you. I remember this.
They dramatize it
a while ago, and I was there with B, one of our other medical legal OTs, and we were both sort of thinking, my goodness, is that really how it works? Is your career over
was the
obliterating?
word that you used.
What would you say to that kind of comment?
No.
It's dramatized, right?
It is dramatized, yeah.
This ain't TV and movies.
I have had a bad experience.
Oh, have you?
Which was not obliterating,
No.
but it was more
You're still
traumatizing
here.
to me. It kind of wasn't my fault. It was preparation. Seeing a client in Emerald the day before, went out to see this cattle guy. It was 43 degrees.
Crazy.
And I got back after 2 hours drive.
Yeah.
And I had the worst case of heat stroke. So I woke up the next day and went, oh, there's no way I can do this trial.
Yeah.
I hadn't looked at the evidence because I was too sick. And so I rang the lawyers and they went,
Too bad.
Too bad. So, the evidence was pretty damning for the client anyway.
The video evidence.
But I just knew I wasn't at my best.
Yeah.
I didn't do my best, and that's what was traumatizing.
So we're going to go into our myth busting section, which we do every episode. So V, my first one for you is that you need to memorize your report word for word before you testify.
Absolutely not. False.
False.
So can you talk us through that?
Well, I mean, it's all superfluous anyway. Like, why would you want to memorize it word for word?
It'll kind of
yourself
box you in,
through.
right?
Oh, totally.
Self-sabotaging.
Too much information to process to answer a question, right? What you want to do is understand every single component of your assessment and your opinion.
Lovely.
And you can put that on one page.
What about V for the second one? If I said to you, your job as a medico-legal OT is to help the client's case.
False.
Tell me why.
Overriding all of that, as an expert witness, we're bound by the Code of Conduct. Our duty is to essentially the judge and the courts and the law. So
Absolutely.
it kind of protects you in that way because you can very clearly defend your objectivity on that basis. Like, no, I know you think he might be able to do more, but it's my opinion and I have to be objective.
Yeah.
Yeah.
Absolutely.
Next one is lawyers and barristers understand medical and OT terminology.
I would say partially false and partially true because they're smart people and they learn fast. So because we've been around for so long, I think they've learned a certain amount. However, you can't assume that. So we just have to assume that they don't. That's why we try to write in lay terms so that in a way that everything is clearly defined and explained so that they can understand it.
And it's not going to cause confusion.
Because really, I've always thought if a lawyer is reading our report, I don't want them to have to go to the internet to Google anything. It should be all in
Already
the report.
in the document.
So
And I
that's
guess
why we footnote.
That's kind of how we structure the report anyway.
What about V if I said to you expert testimony is always adversarial?
Oh, in a way it is, because you've got two sides,
Yeah.
right? So one's trying to say one thing, the other's trying to say something else. So yes, otherwise it probably wouldn't go to court.
Yeah.
I think what's really important that we as OTs just stay steady in our role, which is to help all sides, or both sides, and ultimately the judge, come to a fair conclusion. Yeah. So, look, they will challenge you, but remember, we know our work and we know our report and we know our opinion. And where, like, they ask you a question that you maybe haven't thought of or, you know, that you can't answer it, you just say that. You say, look, I don't believe that, and the information that I gathered is sufficient to answer that question fairly.
That's a great response.
Yeah.
I really liked what you said before about like removing the ego out of it, and I think even though there's two sides, like it can still be done in a very respectful way, like you would hope, that process. So
Yes.
I had a lawyer once say to me that the biggest mistake you can make in some situations is being too rigid in, no, this is my opinion and I don't think anything else, is not being open-minded.
V, what would you say your key advice would be for someone who is stepping into medico-legal OT and starting in that role?
Well, the first thing I would say is join a company that has a lot of experience in medico-legal work, and don't do it on your own.
Yeah.
I'm going to say MLEA because we have such a strong training program, and then all the mentors that you get and all the support that you get along the way. Don't be too hard on yourself. There's a lot of information. Again, at MLEA, you know, you're not going to be asked for anything, to do anything that you're not ready for. So, you know, just, you know, try your hardest, use your OT profession and clinical skills, and just know you'll get there.
Beautiful. I think that's
Love.
great.
Well, thanks, guys. Thanks so much, V, for joining us in today's episode.
Thank you for having me. It's been
Lots of
fun. It's been great.
Absolutely.
So thanks for tuning in to the OT Download. I hope you found that episode really interesting and useful. Please send it to anyone you know that's interested in medico-legal OT, and don't hesitate to reach out if you have any more questions.
Thank you for tuning in to the OT Download. I am Belen, and I'll be stepping in for the next episode for a slightly different kind of conversation. Working in client support at MLEA and as a parent of an autistic young man, I've experienced occupational therapy from both sides. In this episode, I'll be sharing that perspective alongside Ellie, our mental health occupational therapist. We'll be unpacking what OT really looks like for children and adults with ASD, what works, what can miss the mark, and how it plays out in everyday life. I am really excited to share it with you.